All right, July marks the 30th anniversary of the signing of the Americans with Disabilities Act, the ADA. 21 agencies and organizations from across the state are celebrating with a series of virtual workshops throughout the month, accumulating in a big Texas-sized celebration on Friday, July 24th. We will bring you a series of notable disability advocates sharing their experience with the ADA, what it was like to see it implemented, how it has furthered our civil rights of Americans with disabilities, and where it still needs to go. After that, we will take a virtual tour of Texas with brief ADA birthday wishes from local disability advocates across the state. I will put in the chat box the website where you can go and find out more about this information. I'm Randy Turner. I'm with the Governor's Committee on People with Disabilities, and I want to welcome you today. The topic is knowing your rights, how to effectively file an ADA complaint. So I'm going to turn the session over to Norman Kieke.
Great, thank you, Randy. Hello, Texans. Nice to see you. I know we have some people probably from outside Texas as well, so welcome to all the foreigners out there. And before it escapes me, let me be sure to say thank you to Randy and to Ron Lucy and the Governor's Committee on People with Disabilities for taking this on and coordinating all of this, not just the session on July 24th, but all the webinars also. It's a really nice variety of topics that are presented in the webinars, and we've had a great response so far, so we hope we keep that momentum going throughout the month, highlighting the Americans with Disabilities Act. Each of our panelists, I'm the last panelist, but each of our panelists is going to introduce themselves in more detail. You also have this information if you're registered for the webinar, but we'll start off with Rodney Kline from the Equal Employment Opportunity Commission, followed by Georgia Powers with the Southwest ADA Center, and then Lucia Romano with Disability Rights Texas. And then I'll wrap it up with some information about the Texas Department of Licensing and Regulation. And then at the end, we will take questions on all four presentations. So once again, we're glad that you're here. Thank you very much. And with that, I will turn it over to Rodney Kline.
Thank you, Norman. Again, my name is Rodney Kline. I'm an Outreach and Education Coordinator with the EEOC. And I was asked to talk to you today about a little bit about what our agency does, how it interacts with Title I of the ADA, and how you can access the service that we provide. You can go to the next slide, Randy, please. Thank you. Now, most of you are probably familiar with us, but for those who aren't, we at the EEOC, we are a federal agency, and our job is to take and investigate and sometimes litigate employment discrimination complaints. Now, that's discrimination based on race, color, religion, sex, national origin, age, which is 40 and over, genetic information, and of course, disability. In order for a person to file a charge with us or file a complaint with us, there's a couple of jurisdictional requirements that have to be fulfilled. The first one involves the size of the employer. For an individual to file a charge with us that we can investigate, the employer must have at least 15 or more employees. That's true with most of the civil rights statutes that we enforce, including the ADA. So in other words, if you work for an employer that has like 60 or 70 employees, they're going to be covered under the law. If you're working for an employer that has like 2 or 3 employees, then they may not be covered under the law. If we're talking about something that might be a potential violation of the Age Act, that employer must have 20 or more employees for us to have jurisdiction. Or if the issue is wage and gender, which is a very specific allegation, then the employer just needs to have 1 employee. That's one jurisdictional requirement, is the size of the employer. The second jurisdictional requirement involves timeliness. In order for an individual to file a charge with our agency that we can investigate, they have to do so within 300 days of the day they were harmed. So in general terms, once an individual files a charge with us, we can go back and look at issues that may have happened to them within the past roughly 10 months. An individual can file a charge with us. The best way to do that is through our website, which is www.eeoc.gov. And you can go onto our website and enter into a portal that'll tell you how to go to initiate that charge. And as you might imagine, it's going to ask you lots of questions. And at the end of that process, it will ask you if you would like to schedule an interview with an investigator from one of our offices in order to finalize your charge. At the time that it asks you if you want to schedule an interview, it will also ask you if you need an interpreter. So in other words, if you need an ASL interpreter for the interview, that's where you can make that request, and that way we can make arrangements to have that done. If you are in Texas, there are 4 EEOC offices in Texas. One's in Dallas, one is in Houston, one is in San Antonio, and one is in El Paso. Next, please. Who's protected? If you're an applicant for employment, you are protected under the civil rights statutes and the ADA. If you're an employee, and it doesn't matter if you're full-time or part-time or temporary, you're going to be protected under the ADA. And documentation status does not matter. Next, please. So let's talk a little bit about Title I and the ADA. If I were going to make this real simple and real general, I would say that under Title I, employers have 2 obligations. The first obligation is simply that they treat their employees with disabilities the same way they treat all their employees. In other words, that employees with disabilities should not be discriminated against. In other words, a person shouldn't be denied a promotion to a job because that individual has a disability, right? Or they shouldn't be harassed on the job because they have a disability. So that's clearly one obligation that the employer has. But the ADA says that the employer has a secondary obligation too under Title I. And that is the employer has the obligation to consider providing reasonable accommodations to employees with disabilities that will allow them to perform the essential functions of their job. And as you might imagine, because that's a special requirement under the ADA that we don't see a lot of in other forms of discrimination law, that we spend a lot of time investigating those sorts of issues at our agency. So we're going to talk more about that. Next, please. So who's covered under Title I of the ADA? If we're talking about a reasonable accommodation, the employee just needs to have a physical or mental condition that impairs them more than most people. It really is that general. So in other words, if I was a weightlifter, right, and I used to be able to lift 300 pounds over my head, and I have degenerative disc disease, now I can't lift more than 100 pounds over my head. Am I covered? No, because most people can't lift 100 pounds over their head. But if I have degenerative disc disease and I can't lift more than 5 pounds over my head, am I going to be covered now? Yes, it's really that simple because most people can lift 5 pounds over their head. That applies to a lot of the things that are external to us, right? That could apply to walking, talking, breathing, fine hand manipulation, communicating with others. And the list of those things is quite long. But it's not just those external things that we look at possibly being impaired, but also internal things as well, what they call in the law bodily functions. So in other words, if a person's normal cell growth is impaired more than most people, or in other words, the person has cancer, they're going to be covered. Or the person's endocrine system doesn't work like most people's. In other words, they have diabetes, they're going to be covered. So those are for individuals that need accommodations on the job. That's who's covered. If we're talking about discrimination, remember like the promotion or the harassment issues at work, for an individual to be covered then under the law, that individual just needs to have their employment harmed because of an actual or perceived impairment that's not transitory and minor. What's an example of a transitory and minor condition? A cold, right? So anything above that, if the person's employment was harmed because of an actual or perceived impairment, they're going to be covered under the law. The next slide, please. So let's talk briefly about reasonable accommodations. I think most people are pretty familiar with this concept. It can be any sort of modification to the job application process, the work environment, or any sort of privileges and benefit of employment. The accommodation must enable the employee to perform the essential functions of their job, but it may not cause an undue hardship for the employer, because sometimes employers can deny accommodations if it creates an undue hardship for them. The request can either be made by the employee or the need for accommodation may be readily apparent, and the accommodation process should be timely and cooperative. Now, another term that we use for the accommodation process is the interactive process, because I think that's more descriptive of what it's supposed to be like. So the general idea is that once an employee makes a request for a reasonable accommodation, that the employee bring information to the table about their condition, and the employer bring information to the table about the job, and they see if they can find some sort of accommodation that fits both. And that's where we're going to focus our attention. Next, please.
Real quick, Rodney, before we go on,
Yes, Randy.
I would like to pause for a second. Can the cart provider show more lines, please? I know you have to change your system to do that. And the cart provider said, just a moment. Just let me know when you're ready. All right, I think we're ready to go ahead. Go ahead, Rodney. Thank you for your patience.
Great. Thank you, Andy. Now, I've listed some examples of reasonable accommodations, and I think most of us are probably familiar with accommodations. These are just a few, as we know that there are many, many, many things that can be accommodations. The important thing is that each accommodation is going to be unique. Why? Because all conditions are unique and all jobs are unique. So it's not really possible where we're going to have a blanket accommodation that fits all circumstances. Every accommodation should be looked at on a case-by-case situation. Next slide, please. Now, a lot of times what people will ask me is, well, what do I need to know? What do I need to have in order to file a charge of discrimination? Simply put, it's just this. You just need to have a good faith belief that you were discriminated against because you have a disability or that you were denied an accommodation illegally. That's all you need. Our part is to do an investigation to see whether or not we can find the evidence that supports that. So of course, the secondary question is, well, how do I get that good faith belief? How do I know? And of course, that's a much longer session than what I have time for here today. But if I were to offer up something that I hope is helpful, if we're talking about reasonable accommodations, if you're involved in that interactive process with the employer and you're getting the feeling that the employer is not acting in good faith, then that may be something that leads you to that good faith belief, or to lead you to that belief that you might be discriminated against. In other words, sometimes we run into situations where an employee will request an accommodation and the employer will go, no, we're not talking about that. This is the job you do. We're not talking about any exceptions to that we're not going any further with that. That might raise a red flag for you. And I've listed here some cases that we've litigated in Texas over the past couple of years, and I think you'll kind of see some commonality in them. We have one with Austin's Park and Pizza where we had an employee with intellectual disability who wasn't accommodated by the employer and was eventually discharged. What happened was the employer instituted a clock-in, clock-out procedure that was computerized. The employee had a difficult time with that and was not operating it properly. The employer knew that, but the employer didn't offer any additional training to the employee, nor did they offer the employee any sort of alternative to that. So as you might imagine, the employee's time cards were all messed up. They weren't paid properly for the work that they actually did, and the employer eventually fired them. In Fort Worth, we had a case against S&B Industries where we had two applicants were denied jobs repairing cell phones because they are deaf. They weren't denied jobs because they don't know how to repair cell phones. They were denied the job simply because they were deaf. And then we have flying transport out of Amarillo. We had an applicant who was denied a truck driving position because he's missing an arm. Now, he had 20 years experience driving a truck. So clearly he had figured out how to drive a truck with one arm, and he had all the proper Department of Transportation certifications and license. In each one of these cases, in a real simple sense, is what I was describing. In other words, we had employers in all three of these situations that just got to the point where they said, we're not talking about this anymore. We're not going to make a good faith effort. We're not taking that next step forward. So I think that's a good rule of thumb if we're talking about reasonable accommodations in Title I and developing that belief that maybe something that's going on is not right. That does not automatically prove that you were discriminated against, but it may very well offer up a red flag for you, and it certainly might be worth a conversation with us and considering whether or not you wish to file a charge. So that's what I have for you this morning, and hopefully that information about who we are and what we do and how we interact with Title I is helpful to you. So now I would like to turn this over to George Powers of the Southwest ADA Center.
Hi, thank you, Mr. Kline. I'm George Powers from the ADA Center, the Southwest ADA Center. Next slide, please. So the ADA Center, there's 10 of us across the country. What our role is to explain what the law states and provide guidance. I'm going to be focusing, next slide. I'm going to be focusing on Title II today, which deals with pretty much anything a local or state government does. Next slide. So I think, like, to really understand the law, it's important to understand what the purpose of the law is. Next slide. One more, please. Yeah. And that's pretty much to ensure that people with disabilities have equal access to everything. Like Mr. Kline said, Title I deals with employment. Title II deals with the services local and state governments offer. And as my next presenter, or as the next presenter will be talking about, Title III is public accommodations. Next slide. So Rodney kind of addressed this, but essentially the ADA applies to any person who has a disability, a person who has a record or is regarded as having a disability, or those that have an association with a person with a disability. And you know, a disability is defined as a physical or mental impairment that substantially limits a major life activity. But it's not really important to focus on that, on the definition. It's more important to focus on, you know, the accommodations and whether or not the services are accessible. Next slide. So one important point, I think, is that sometimes we get calls from people who have disabilities and they're facing bad situations. But it's not really because of their disability, right? So the discrimination that you're experiencing has to be because of your disability. Next slide. And as I said, the Title II of the ADA applies to the services, programs, or activities that local or state governments have. And that's a very broad term. It essentially applies to everything that they do. Next slide. Some organizations or some entities that this would apply to are like public transportation services. Next slide. Public libraries, public schools, the fire department, the police department, and so on. Pretty much anything that's under the guise of state or local government, needs to be accessible. Another key issue that we deal with a lot is effective communication. People who are deaf or blind need to have the same access to the services and programs that these governments offer. There's a slight difference between Title III and Title II in that local governments have a stronger obligation to give a primary preference to what the person requests. So if a person requests an ASL interpreter, the local government has to give that like a primary consideration. Like they have to do that. They have to give that request primary preference, which is quite different than what a Title III entity has to do. Next slide. One more, please. Yeah, and another thing is like businesses when they're inaccessible, like stores like Walmart and stuff, they have an obligation which is called the readily achievable barrier removal standard. It's a bit different under Title II. Next slide. You have to look at the program or service in its entirety. I mean, these are all very complex issues, and I'm just trying to cover the basics in the 15 minutes I have. Next slide. Yeah, so for example, like if there's multiple public swimming pools in a city, there's not really an obligation to go back and make every one of those pools accessible. You just have to look at that program and that service in its entirety and see if it's accessible. Next slide. So recently we've been getting a lot of calls about concerns that people have with COVID-19. Specifically, especially now there's a lot of requirements to wear masks. Local governments and state governments have passed regulations or laws that require people to wear masks when they go out into public places. And unfortunately, what we've discovered at the ADA Center is that there's these cards that are going around that say that they're exempt from wearing a mask because they have a disability. That disability may be something like asthma or COPD, something that makes it hard to wear a mask. And so they present this card that says, I don't have to wear a mask because I have a disability. First off, these cards are not valid. They're not from any government agency or anyone with any authority to make that determination, right? But if you are someone that has a person with a disability, if you are a business or a government entity that has someone that comes in and says, I can't wear a mask because I have a disability, this is kind of how you have to analyze it. First, is their concern legitimate? Do they actually have a disability? Don't focus on that too much. Just kind of take their word for it. And if they do, then you have to look at this health and safety concerns. Under the ADA, it's called direct threat. So you don't have to accommodate someone if their request creates a direct threat. So in this case, that may be that not wearing a mask can create a health and safety risk to others. And what you need to look at is legitimate evidence, like legitimate medical empirical evidence. Like the evidence that like the CDC or the World Health Organization puts out. And there's plenty of evidence stating that not wearing a mask, even if you don't have any symptoms, creates harm, creates significant risk to others. So in that scenario, most people can be denied services for not wearing a mask. However, the analysis doesn't end there, right? You still have an obligation to accommodate those with disabilities. And that may include something like curbside services or, you know, I know around here, we have in the mornings, they have in the grocery stores like specific times for elderly people to attend the store. I mean, they still have to wear a mask, but I'm just saying you still have to explore ways to accommodate them reasonably and effectively. Next slide. So another issue that we often deal with at the ADA Center are housing issues. We get a lot of, I mean, this doesn't have to do with Title II specifically, it's just something we deal with a lot. It usually has to do with like the landlord and tenant relationship. Like someone rents an apartment and then they find out that there's no parking space, near there's no accessible parking space near their unit. The good thing is that the Fair Housing Act, the guidance and the regulations state that you have a right to a reserved accessible parking space as a reasonable accommodation. A lot of people don't know that. Another issue that we deal with in the housing aspect is assistance animals, whether it's emotional support animals or service dogs. And landlords usually don't like animals. So that comes up quite often. And then finally, just like reasonable accommodations and modifications, whether it's changes to the policies that a landlord has, or like modifications, like structural modifications you need to make to the apartment. So just keep in mind that if you need to make something in your apartment accessible, like the tub, like the handlebars, or a ramp, you're responsible for that cost as that tenant. The landlord is not responsible, you are. So before you rent, just keep that in mind. Next slide. Yeah, and I just want to reiterate that at the ADA Center, we're not the police, right? A lot of people, when they call us, they think that we're the ADA police. And the enforcement agencies are like the EEOC, the DOJ. The ADA is enforced pretty much like every other civil rights law. Rodney touched on it a little bit, but it's enforced through complaints and lawsuits. So there's no such thing as an ADA police. You have to either call the correct federal agency or hire an attorney to pursue justice. And also keep in mind that these enforcement agencies are always very overwhelmed, and the resources they receive depends on the executive administration that's in power. So when you vote, keep that in mind, right? If you want access to society and you're a person with a disability, just this November, keep that in mind. And now I think my time is up, and we're going to move on to Lucia Romano, who's going to talk a bit about Title III, and she's from Disability Rights Texas.
Thank you, George. And welcome everybody. I'm glad so many people were able to join us this morning. My name is Lucia Romano. I'm a supervising attorney at Disability Rights Texas. We can move on to the next slide. So what I'm going to be talking to you about today is Title III of the Americans with Disabilities Act. And like George mentioned, Title III and Title II are very similar. There's some differences, but Title III focuses on private businesses, what is called public accommodation. Next slide. So I think the speakers before me have gone through this. Just this slide is a quick overview of the Americans with Disabilities Act and its birthday this month, 30 years. It is divided into 4 sections. Title I, again, about employment. That's what Rodney went over earlier. Title II, that is what George just finished talking about. It prohibits discrimination by state and local governments. I'll be talking about Title III. And there's Title IV, and that prohibits discrimination by telecommunication entities. Next slide. We talked a little bit about disability and how it's defined. Again, I think this is, the speakers have gone over these things, but again, it's a condition that substantially limits one or more life activities. There's a record of such impairment, or the person is regarded as having this impairment. Next slide. The one thing I will have to say about the definition of disability is that in 2008, the ADA was amended, and it was amended to clarify the issue of disability, because there were a lot of cases, particularly in the employment arena, so under Title I, that were coming out pretty negative as far as decisions from judges that were saying that, conditions and things that we would typically think are disabilities were not disabilities, and these cases were being thrown out of court. So there's a big movement to kind of clarify what is a disability. So right now, really under the ADA, there is a long list of several conditions that fall under what is defined as a disability under the ADA. And also major life activities was defined. And these are some of the areas that are considered major life activities under the law. Next slide. So let's focus on Title III. Like I said earlier, Title III prohibits discrimination on the basis of disability in terms of public accommodation. So people with disabilities should have equal access to enjoy the goods or services that these businesses offer to the public. So Title III entities, what is a public accommodation, and what does that look like? So when you think of hospitals, banks, theaters, stores, hotels, all of these things are public accommodations. Next slide. So Title III requires that businesses that are open to the public provide reasonable modifications to their policies, practices, so that their business is equally available to people with disabilities. So for example, if a restaurant has a no pets policy, they have to modify that policy to allow a person who has a disability and uses a service animal to come into the restaurant with their service animal and enjoy their food. Next slide. What about physical barriers to businesses? So all new construction and modifications should be accessible to individuals with disabilities. And then for existing structures, barriers should be removed if readily achievable. So this is what George had mentioned before, that there is, at a minimum, certain things have to change within the business to make it accessible to a certain point, if it is not. Next slide. George mentioned this as well, effective communication. So we see a lot of these cases as well as in Disability Rights Texas. Title III also requires public accommodations to provide what is in the law as auxiliary aids and services so that an individual with a disability and who has a communication disability would have equal access. Some of these services may include ASL interpreters, written materials, visual materials, qualified readers, and much more. Next slide. We also see lots of cases regarding service animals. And, you know, what is a service animal? So under the ADA, which is different than the Fair Housing Act, a service animal means any dog that is trained to work or perform a task to benefit an individual with a disability, any disability, and the sole function of the dog cannot be emotional support or comfort or well-being. So under the ADA, it's very important that the service animal, which is a dog, the person with a disability has to articulate what services that dog can provide the individual, so that individual can be out in the public using services or products or being able to access businesses that provide services or products. Next slide. Next slide, please. So we get a lot of questions.
Sorry about that. I apologize.
No problem, no problem. We're all learning technology. Now in this new COVID world, we're having to readjust and learn new things. So thank you, Randy. Under the ADA, a business can really only ask 2 questions if an individual with a service animal, approaches the business or wants to come into the business. Is the animal required because of a disability? And what work has the animal been trained to do? An employee or a staff of that business cannot ask details about the disability, cannot ask for proof of the disability. In other words, medical documentation because of the disability. Can't ask for a special training certificate or card or tags, or for the dog really to demonstrate how it performs that specific task. Next slide. Another couple of things to keep in mind regarding service animals. Again, a lot of people think that the service animal needs to have a badge or a vest or a card identifying it as a trained service animal, and that is not required under the law. And a business can exclude a service animal for certain reasons. If the animal is out of the handler's control, if the animal is not housebroken, if the animal poses a direct threat. So again, George had mentioned that earlier, that's one of the things that a business can, keep in mind as far as excluding an accommodation or excluding a service animal, is that if it poses a direct threat. And also if the animal or bringing the animal into the business changes the nature of the business, the core of what that business is about. One thing I will say about excluding the service animal, a business can exclude the service animal for these reasons, but the business has to be made available to the person with the disability without the service animal. So, you know, a restaurant owner can say, I'm sorry, your animal is out of control and, you know, is growling at other customers, and it seems like it could pose a threat to our other customers. So we would ask you to take the animal outside. You are welcome to come back to our restaurant, but we can't have this animal within our restaurant. Next slide. You know, I think George covered this very well. We are getting a lot of intake requests regarding COVID-19 under, really, I would say, Title I issues with work, and also Title III. And people are asking a lot about, what if I have a condition or a disability that prevents me from wearing a face mask? I will say, I'm sure we all know here in Texas that the governor has issued a mandatory face mask requirement, but there is an exception for people with medical conditions or disabilities that prevent them from wearing them. There are no specific rules under the ADA or regulations about the use of a face mask in times of COVID-19 and the pandemic. The DOJ has not issued any guidance yet or any regulations on this. So with all that being said, we are just as much kind of trying, it's a very fluid kind of changing thing, and trying to learn as much as we can about this issue as well. Next slide. I think that George talked about this too, is that, you know, we have to go with what we know about the ADA, and public accommodations have to, under the law, consider modifications to their policies. So a business can require a face mask, like they can require, for example, a lot of businesses have that sign, you know, no shoes, no shirt, no service. They can require certain things, but they would probably have the obligation under the ADA to consider or offer accommodation. And some of the things that George said, and I have here too, is curbside service, or maybe, you know, a face mask. If that doesn't work, they have those face shields. That might be better. I've also looked into, there are face masks with different fabric that may work better for people with certain disabilities. So those are just a few options. Next slide. Like I said, what we know about the pandemic and this virus is quickly evolving. So all of this, as the science becomes clearer about this, this virus, may change. So the public accommodations would, and right now do have a valid argument on, you know, insisting to require a face mask. But it's our position is that they would have the obligation to consider accommodations. Next slide. So I have some information about how to file a Title III complaint. And this can be done online, and I have the website there. It's a kind of a form that you can fill out this form and information through an online portal and then submit that complaint. It's accessible and offered in many languages. You can also directly file by calling, and I have that information here, faxing, a complaint or mailing a complaint as well. Next slide. You do not have to have a form to file an ADA Title III complaint. I have listed here what information should be included in a complaint. So let's say you call them or you decide to put together a letter and send them a written complaint. These are the types of things you want to make sure that you make sure that you put in the complaint. So a description, your full name, address, how to communicate with you, the name of the business, as much information as you know about the business or the employee, staff person that you feel discriminated against you, and a description about what happened. If you have any relevant documents, for example, pictures, if the issue is effective communication and the individual was made to write back and forth instead of the business providing an ASL interpreter, make sure you keep those notes and add that to your complaint. Next slide. What happens after you file a complaint? What happens to your complaint? So there are several things that can happen. The DOJ may contact you for further information to clarify some things on the complaint. That may be from their like intake person. It could be assigned an investigator. It could be sent to the mediation program, which is called Key Bridge Mediation. Or they could just send you a letter basically saying, we don't have resources, we're not going to investigate this issue further. I have one thing to add about the Key Bridge Mediation. And I know when we file DOJ complaints on behalf of our clients, as a routine practice, we make it bold and clear that we are requesting mediation through the Key Bridge mediation process. Oftentimes, we have used that program and have had very good results through that program. And I'll kind of give you some examples in just a bit. So what mediation is a way to resolve a dispute in a less adversarial, resource and time-intensive manner than going to court or than going through the DOJ investigative process, which can take years and a very long time to do. I will say that we find that the Department of Justice tends to be more interested in larger systemic complaints. So if your complaint is against a small mom and pop shop, that might not garner as much interest from the DOJ as if your complaint is against, let's say, a large hospital system that's nationwide. Next slide. Other factors to keep in mind, and some of these are very important. So typically you have 180 days from the date of the discriminatory act to file a complaint with the DOJ. You can also bring a private cause of action or a lawsuit for a violation of Title III of the ADA. And you can have those going on at the same time. So let's say that you file a DOJ complaint and you're kind of waiting for the results about, the results, or you're waiting for the DOJ to do some work on the complaint, and you're getting close to that 2-year statute of limitations to file a lawsuit. You can go ahead and do that. There's nothing that prohibits you from filing a lawsuit while the DOJ complaint is pending. One thing I will say about filing a lawsuit We get a lot of clients who have maybe some misconceptions about the type of relief that is available under the Americans with Disabilities Act for violations of Title III. Oftentimes, clients are looking for monetary damages, so a payout for a violation. The ADA does not provide for such relief. The ADA provides for equitable relief, so requiring a hospital, for example, to change their policies and practices in terms of effective communication. A restaurant, changing their practices nationwide so that they have a service animal policy and train all their staff. But financial damages is not something that the ADA Title III provides. Next slide. I wanted to talk a little bit about Disability Rights Texas, if I have a little bit of time. But before I do that, I wanted to give a couple of examples of DOJ complaints that we have filed that have had pretty good results. I have filed several DOJ complaints against hospitals for effective communication issues, and also large dental practices and that sort of thing. One case I did have was against a large dental practice, a pediatric dental practice. And what we did is we filed a complaint and we went through Key Bridge mediation. And so through that process, we were able to get the policies and practices changed. We were able to get training for staff, and not only the location where my clients tried to go to, but this particular practice was stretched across Texas in the South. So they had locations across several states. So this was across the board changes. My client was a young man, but the mother and the young man were involved, very actively involved in the deaf community, and they were involved in certain organizations for families who have deaf individuals in their family. And they had like a yearly conference of some kind, and we were able, through the complaint and the mediation practice, to ask that entity provide packets of kind of well dental care information and toothpaste and brushes to all the kids of these families for this conference. And the toothbrushes had on the toothbrush itself in ASL something like brush every day or make sure to brush every day. And it was in ASL on the toothbrush. So we got several of those that they were able to take and hand out to the people at the conference, attendees. Another example of a good DOJ complaint result is with a service animal and a hotel chain. We also got them to change their practices regarding service animals and allowing service animals in the hotel. And what happened with our client is she was traveling to a different city to attend the graduation, I think, of a nephew, and had a hotel reservation, brought her service animal. When she arrived with the service animal late at night, they told her that the service animal was not welcome. They don't accept pets in the hotel. And so she couldn't check in. It was late at night. She had to drive around and try and find a hotel well into the early hours of the morning that had availability that she could stay at. So in that situation, we were able to get some of her a refund because she had to pay for a more expensive hotel and whatnot for that stay. So those are just a couple of examples of some good results that we've had. We've had quite a few through the Key Bridge mediation program. Now, real quickly, Disability Rights Texas is a statewide nonprofit legal organization. We take cases in the following areas. We have different teams that cover these different areas. I'm the supervising attorney that covers the area of accessibility, voting, and employment. So I also work with with advocates who work with the vocational rehabilitation program. So these are some of the things that we handle. Next slide. A couple of our data from 2017, that's what was compiled that I could have access to. We had 6,422 service requests, over 4,000 active cases. During 2017, we accepted close to 3,000 new cases, and we had over 100,000 people were trained through our outreach efforts as well. Next slide. I thought it would be interesting for you all to see, we talked about, COVID-19 related cases, we're tracking that. And so far we've had over, 167 COVID-19 related education issues, 35 employment, 44 housing, accessibility 33, even voting 3, community integration and healthcare 48, and institutional rights for people with disabilities and civil liberties, we've had 22. On top of that, we've created a lot of handouts, videos, informational pieces in terms of COVID-19 related, like new laws and things that have come out. Next slide. Thanks everybody for taking the time to come today and listening to all of us. We'll take questions at the end, but right now we're going back to Norman Kieke.
Take it away, Norman.
Thank you, Lucia. Boy, this has been a lot of information and some really great resources for everyone and everyone beyond this webinar to stay in touch with and to reach out to for answers to questions that we touched on already or any other issues that may come up. Rodney talking about Title I, the employment issues, the various protected groups. I've been through training on this at work, and there are a lot of different protected groups, including people with disabilities. And so even as a person with a disability, you may fall into a second or third protected group as well. So there's lots of opportunity to avoid employment discrimination, whether it's being hired or being promoted or being treated fairly in the workplace. George with the Southwest ADA Center talked about Title II issues, local and state government, brought up the very relevant issue right now of face masks, as did Lucia. And there's no provisions against that prevent requiring someone to wear a face mask in your business. I had a conversation with a representative from the Department of Justice, who, by the way, the DOJ is very good about answering their phone and discussing issues, but they don't put anything in writing. As you've heard a couple of times during these presentations, it's always so important to take good notes and take the name of the person you're talking with. But the response I got from DOJ was what you've heard today is an employer and a business can make a rule that masks have to be worn in their place of business. But a place of business should also be ready to make a reasonable accommodation. One of our programs here, cosmetology, where you get your hair done and your nails and your eyebrows, they had a call from a customer that let them know that she could not wear a mask due to her disability. And they offered accommodations like going to her house, providing services before or after hours or on the days that they were closed. So the owner was cognizant enough, astute enough to know that she needed to make some accommodations for this person so it didn't escalate into a complaint. And the DOJ pretty much affirmed that with me when I called them about this. George also talked about housing issues, parking issues, reasonable accommodations. So lots of good resources there with George and any of the 10 ADA centers. And then Lucia bringing in Title III businesses and public accommodations. Again, the need to make reasonable accommodations to provide access. George and Lucia both brought up service animals, and again, Lucia brought up face masks. We get questions about that regularly at my program, which I will talk to here in just a second. But Lucia also talked about physical access into businesses and facilities, and that's what my job is about, is physical access into businesses. The ADA that we've talked about is a civil rights law, and rightly so. And it does a lot of good work protecting people with disabilities to be able to access all the various components of the various titles, Titles 1 through 5 of the Americans with Disabilities Act. So it is a civil rights law. I'm with the Architectural Barriers Program at the Texas Department of Licensing and Regulation. Our law, which is called the Elimination of Architectural Barriers, is a construction law. So it's almost completely different from the ADA. The one common theme that we do have is the accessibility standards for buildings and facilities. And so I'll talk about that in a little bit. I want to talk just a little bit about TDLR, the Department of Licensing and Regulation, just because it is a broad agency. And we do have certain programs that directly impact people with disabilities. But as we all know, any program that we have, whether it's tow trucks or boxing matches, is also going to impact people with disabilities. Our mission, next slide, please, is to earn the trust of, there's our logo, that's our new logo. Our mission is to earn the trust of Texans every day by providing innovative regulatory solutions for our licensees and those they serve. Every 2 years, we are challenged to become a little bit more efficient, a little bit less tied to paper and questions and forms. We do struggle with that, but trying to be innovative with the services that we do offer. Next slide. Our vision is to be the best at creating next practices or best practices that deliver low-cost licensing and regulatory services as an exceptional customer experience. So we love to hear from our customers, not only in our program, but the 40 other programs that are under TDLR, that we're doing a good job regulating, dropping costs, dropping the requirement for certain licenses. Again, we do that every 2 years. We look at everything across the board. Again, the next slide, our philosophy is honor the public by being fair, transparent, efficient, value customers and coworkers, foster innovation, there's that word again, innovation and change by challenging the status quo, recruit, empower, and reward high-performing employees. We have a lot of folks that have been in our agency for 20 or 30 years. I've been there 13 years. I think that speaks very well to how our employees are regarded at the agency, and that I'll say it, we're trying to do a good job with what we do with our programs. And then again, capturing it all, transforming programs and improving services for our customers. Next slide. I just threw up a sampling of the 41 programs that we do have. Several having to do with buildings. As you look at this list, you see air conditioning, electricians, elevators, possibly mold assessors. That's one of our new programs. It's very important. But then also mixed in with combative sports. The average man on the street is not aware that at every boxing or martial arts match in the state of Texas, TDLR is ringside with a physician and a staff person, and usually a volunteer. If you do have an interest in combative sports, you have an opportunity here to be a volunteer in the state of Texas and be ringside with a front row seat, checking the vital statistics of the contestants, checking what they're wearing, their equipment, being sure there's nothing in their corner of the ring that's going to violate rules and regulations. It's all very important stuff. So that's a big surprise. I already mentioned cosmetology, but we also do barbers, motor fuel metering. When you fill up your car with gasoline, the next time you do that, check out the gasoline pump. There's a tag there. It used to be from the Department of Agriculture, but we're in the process now of changing those tags to TDLR tags. So if you do see a problem with the gasoline pump, whether if there's something attached to it that shouldn't be, like something that's reading your credit card, or if it's not metering correctly, as the sign says, you're paying $1.75 for gas, but it seems to be charging you $2 a gallon for gasoline. That's something to report to TDLR. And then tow trucks. That every tow truck you see that's regulated is going to have a TDLR number on it. So that's just a small sampling of our 41 programs. Most of our programs have advisory committees, volunteers from around the state, appointed by our TDLR commissioners who are appointed by the governor. So it's kind of a trickle-down effect from the governor's office to the TDLR commissioners down to our various advisory committees and boards. So a lot of involvement with our programs. The next slide. We have 9 programs that I mentioned that do directly impact persons with disabilities. We're the longest standing program at TDLR, the Architectural Barriers Program, doing our best to make Texas accessible for all Texans as well as visitors to our great state. I'll talk about the ABE program a little bit more, but the other programs that we've only taken over recently, behavior analysts, we have about 2,000 of these folks in the state of Texas. Very low complaints, since we're talking about complaints with this program. In 2019, only 14 complaints. In 2020, only 22 complaints. So when you consider 2,000 practitioners, that's a very low number of complaints. Driver education is a program that came from the Department of Motor Vehicles. So we're the folks now that are working with the people that provide driver education. So if you go to a safe driving course, the teacher, the instructor, the curriculum is guided by the Department of Licensing and Regulation now. We've also recently taken over motorcycle safety. So that's not even listed in our programs, but it will be soon. So that came over also from the Department of Motor Vehicles and Department of Public Safety. Dyslexia, therapists, hearing instrument fitters, orthotists, and prosthetists, always have a problem with that word. Podiatry, speech language pathologists, again, and audiologists. I have a hearing aid, so that's really important to me to watch that group. But again, programs from the Department of Health and other health agencies at the state of Texas that came over to TDLR. We've reduced all the language and the rules for these programs. We're looking in the future at looking at the laws that regulate these programs so they're more readable, easier to understand, just more user-friendly for those of us that occasionally look online at information like this for these various programs. And then finally, transportation network companies. Again, the man on the street doesn't know what that means. We're talking about Uber and Lyft, those services that use private individuals, mostly with their private cars, to go to various locations in big cities mostly to provide transportation. More affordable transportation, more reachable transportation, unfortunately not necessarily more accessible transportation. So part of our charge with getting this program transferred to the Department of Licensing and Regulation is looking at how we can try to help make these programs more accessible, that is, have more van accessible drivers out there, whether it's providing the vans for them or providing the means for drivers to get vans or vehicles that can be made accessible for larger wheelchairs. Because right now they're pretty much limited to the standard wheelchairs that they can fold up and put in the back of their cars. Even some of those are too large. If a driver shows up in a very small car, they may not be able to fit a large standard wheelchair into the back of their vehicle. So it's very problematic. I'm happy to say the Governor's Committee is looking at this issue with a lot of interest and trying to help find solutions for these programs that have really transformed the public transportation opportunities. So talking about let's go to the next slide. We have new challenges everywhere. Oh my goodness, on my cubicle wall, I have a wall of shame of pictures. And honestly, the pictures on my wall of shame are worse than the pictures I'm going to show you here. But a toilet that has a floor drain to the side, it looks like it may be too far from the wall in the first place. A grab bar that's not regulation grab bar on the side, but no grab bar in the rear. There's a flush mechanism up above, way out of reach, and the toilet paper is on top of that flush mechanism. So if you're not even able to stand up, you're at your own devices there for that need. The sink is way too close to the toilet. I could go on and on about this picture, but like I said, this is not even bad enough to make my wall of shame. Although I think I just mentioned 8 violations of the accessibility standards. So the next one, please. Yeah, this is actually one of our inspections down in Houston. A general contractor was let loose on this intersection and forgot to put a curb cut through this island, which is the way a pedestrian would get to the pedestrian button to change the light to walk or cross now, the crosswalk button. So unless you happen to be stretcho and you can reach that push button from one side or the other, you're just out of luck. You have to, or maybe you carry a long pole with you, you could reach that. So we see these things, we just scratch our heads and then slap our foreheads, and very quickly the city of Houston was back out there with their contractor putting a curb cut through this island. Next slide. This reminds me of my father. They had a problem with the water line getting to that water fountain, that little black tower in the back. And rather than tunneling underneath the sidewalk, which honestly is pretty easy to do because I've done it myself at my own home, they just put a water line over the sidewalk. And then to protect the water line, they built this wooden barn over it that looks like it's at least 2 inches tall and 4 inches wide. So imagine being somebody with a mobility impairment, especially using a wheelchair, but bad enough if you're on crutches and it's raining and you have to go out into the grass and you can see mud on the side of the sidewalk. This is where you need a sign that says turn around, go back. So this is the real world. This is what we see out there. This is a really popular barbecue place in a town very near to Austin. Bless their hearts, they tried to create some accessible parking. So they put up a sign. It doesn't say anything about van accessible. This is the only accessible parking space at the facility. It's a gravel parking lot, so there's no opportunity to put markings on the surface for the parking space, much less the access aisle. Even if you do park there and get out and you're able to maneuver across the parking lot, there is a ramp into the door, but the access onto the ramp is near impossible. At one end, there's about a 3-inch drop. On the side, they poured some asphalt, which in the Texas heat literally melts away. And I've seen people wearing high heels step onto that asphalt and their high heel just sinks into it, even on just a regular warm day in Texas. So they were trying to do the right thing. They just didn't quite make it. Again, I'm looking at about 8 violations of the parking standards here. And I know they have the money to pour some concrete there and create a van accessible parking space. If you have only one accessible parking space, it has to be the van accessible parking space. So that's it that we're looking at. I think we have a couple more slides. No, this is the last slide. This is a diagonal curb ramp, which, by the way, we're trying to move away from. The highway standards have done away with these diagonal ramps. Unfortunately, we know we're out there. So in a renovation project, the diagonal ramp will stay. One issue with these diagonal ramps is if you're visually impaired and you're not familiar with the location, the diagonal ramp leads you out into the middle of the intersection rather than across where the crosswalk is to the other corner. Not to mention that the detectable warnings here are placed completely inappropriately, incorrectly. It looks like there are other issues with this ramp. At the top of the ramp where the cars are lined up, it looks like there's a change in level. I wish I could say that we're a shadow, but I think it's a change in level, at least an inch. And then even at the bottom of the ramp, there are issues there where it looks like they tried to create or do away with a change in level at those bricks, the detectable warnings. So this is just another one of those locations where they just need to go ahead and put up a sign, turn around, don't even try to go across here. So again, we're trying to do away with these diagonal ramps. They're not in the new standards, but we have to acknowledge the fact that they are there and they're going to be there for many years with renovations that are forthcoming. So I think those are my slides. Our program, the Architectural Barriers Program, I'm going to go back a little bit, Randy, here. You can stay there on that slide, but a little bit more about our Architectural Barriers Program. We have 25,000 licensees every year. That includes our registered accessibility specialists who are all over the state. These are independent contractors that have been trained to know the accessibility standards, the Texas accessibility standards, as well as our law and our rules. And they have the ability to do plan reviews, look at a plan set before a building is constructed, to mark up violations of the accessibility standards and let the architect or the builder and the owner know that they've got some violations that they need to correct prior to construction. These accessibility specialists, we call them RASs, after the building or facility is built, then they go out and do an inspection to be sure that it was constructed to be in compliance. They try to go through the process with the owner or whoever is in charge of the project to correct the violations. They have 9 months to do that. If they don't achieve those corrections in 9 months, then the file is turned over to us in the Architectural Barriers Program, and we follow up with it. In 2019, we only had 64 complaints. In 2020, we've had, at this point, just 102 complaints. I know from looking at these complaints that the problem is, and other speakers have alluded to this, you need to be sure your information is complete and correct for our investigators to be able to follow up on it, especially if you file a complaint anonymously. I had one of our investigators come down to my desk one day and dropped a piece of paper on my desk and said, "What would you do with this?" The complaint, anonymous, said, "There's a taco stand in North Austin that is not accessible." And, you know, just by a miracle, the fact that I'm an Austinite and I travel around the city a lot, I told the investigator to go out to this stand that I knew of in North Austin. And when the investigator drove up with a TDLR truck, the owner came out and said, "I know why you're here. I know who filed the complaint. I'm working on it." If the complaint had been in Dallas, I would not have had a clue of a taco stand in Dallas that's not accessible. So I think the problem is we're not getting complete information, not just on our complaints, but on complaints with all of our other programs that I've mentioned. And this probably happens at the federal level too, with complaints not being filed with complete information. And especially if the complainant is reticent to offer their own personal information so the investigator can be back in touch with them. Regardless of that, our other 24,000 licensees are construction projects that are going on around the state. Everything has slowed down with COVID, but not our construction. We are barreling ahead in the state of Texas with construction projects from the Panhandle down to the coast, from El Paso over to the border of Louisiana and every place in between. Construction is going crazy in Texas. There's a lot of opportunity for RASs, the Registered Accessibility Specialists, to the point that some are turning down business. So there's a lot of opportunity there for folks who are interested in this business. A lot of times it takes a personal interest in being involved in disability issues, but sometimes it might just be an architect that has moved into this area to try to help ensure accessibility in the state of Texas. So our topic, complaints, very easy. You can go to our website, tdlr.texas.gov. You can do the backslash complaints. Or if you just go to our website, tdlr.texas.gov, there's going to be a big red bell on that page that says register a complaint. So either way you can get there. If you happen to get to our architectural barriers page, we also have a link similar to that, register a complaint. It's very easy. Like I said, you can do it anonymously, or if you really want to be helpful, you can let us know who you are and how we can reach you. Once you talk to the investigator, you can ask that they not reveal your information. So there's always that opportunity too, just to be sure that your complaint is thorough and that we can address it. We address these complaints very quickly, within 1 or 2, at the most 3 days. So please let us hear from you. You can also email in a complaint, intake, that's INTAKE, intake@tdlr.texas.gov. A little bit more information, the next slide, please. Our good buddies at the Access Board, these are amazing people in Washington, D.C. You can email them at info, I-N-F-O, at access, down at the bottom, access-board.gov, and you will get a written response from the Access Board about your question about the accessibility standards. You may even get a phone call. If they want to discuss it with you, if they don't have all the information they need, they may give you a phone call. I think about half the questions I send them, I get phone calls on, but they're very, very responsive to emails. So the second option is enforce, E-N-F-O-R-C-E, enforce at access-board.gov. There's a fax number. I don't know if anybody's still using faxes, but 202-272-0081. and then their mailing address if you want to write something out for them to the U.S. Access Board, 1331 F as in Frank, F Street, Northwest, Suite 1000, Washington, D.C. 20004-1111. Again, their website, www.access-board.gov. One more slide to go, I believe. We've already given you a lot of resources on ADA complaints. All 4 speakers did. I just gave you some more. We have a shameless plug here for voting. Not just the upcoming election, but any election. It's so important to vote. It's a neglected responsibility, a neglected opportunity in the United States that other people in other countries take very seriously. So please go vote. Don't think that your vote doesn't matter, because it does. Again, a big thanks. I'll wrap it up here. A big thanks to our 21 partners in this effort for the ADA celebration, as well as to the, excuse me, the Governor's Committee on People with Disabilities, with the staff over there really taking a large role in this 30th anniversary celebration of the ADA. Thank you very much. Randy, I guess I'm tossing it back to you. Randy Turner, thank you.
Thank you, Norman. I appreciate you wrapping up there. And I'm going to go ahead and read off the list of partners for individuals that may not be able to see the screen. American Council for the Blind of Texas, ADAPT of Texas, Art Spark Texas, Coalition of Texans with Disabilities, Disability Rights Texas, Governor's Committee on People with Disabilities, the National Federation of the Blind of Texas, Community Attendance Equal Independence, Rev Up Texas, the Southwest ADA Center, Texas Association of the Deaf, Texas Council for Developmental Disabilities, Texas Department of Licensing and Regulation, Texas Workforce Solutions and Workforce Commission, the Statewide Independent Living Council, the ARC of Texas, the University of Texas at Austin Center for Disability Studies, and the Texas Department of Transportation.
And Randy, let me throw in a couple of extras. I think they were at the bottom of your screen. Nobility and Texas Parks and Wildlife Department.
Oh, thank you for catching those. I
No
appreciate that. And I wanted to say one last thank you to our speakers today, Rodney Kline from the EEOC, George Powers from the Southwest ADA Center, Lucia Romano from Disability Rights Texas, and Norman Kieke from TDLR. Thank you everyone for joining us today, and have a great rest of the day.